SJC-13093, Commonwealth v. Martin P. Curran.
Sorry about that. Be one of those mornings, I guess. Good morning. My name is Attorney Robert Spavento. I represent Mr. Curran. May it please this honorable court. As you can see from my brief, Your Honors, this is a case that happened back in October with a Zoom bench trial. And the main issues in this case is prior to the bench trial, while the defendant received a jury waiver, the judge never attempted or in any way did a colloquy informing the defendant of certain rights. This is very important, Your Honor. The first thing I would like to talk about is whether or not a colloquy is required.
Before you do that, could you, the record, I think I have the whole record, but was there a discussion of how the Zoom trial was going to work? Because I can't tell from here at all what the parties understood how they were going to conduct the Zoom trial.
According to the record, I don't see anything in the record which states, okay, ladies and gentlemen, this is how we're going to attack this trial today. It was from reading the transcript and everything else, it was just, the judge basically said, okay, let's go call you first witness, for the lack of better words, after he did the jury waiver.
So when we have the full, so we have the full record here, because I can't discern whether there's any discussion of the ground rules of the Zoom trial. So we're not going to find anything on that?
No, the whole trial itself was probably half hour, 45 minutes from.
Yeah, I read the trial. I'm just wondering, there was no preliminary discussion on the record of how they were going to do the Zoom trial?
No, Your Honor. I checked the whole entire docket sheet. I know Commonwealth did as well, looking at past pre-trials to see if the judge said, okay, this is how we're going to officially do a Zoom trial.
Mm-hmm.
So I do not have that, Your Honor. That's why one of the issues is so important, because there were no ground rules in this trial. As the transcript showed, the defendant was broadcasted from the jail. One witness was broadcasted through Zoom, and two other witnesses were actually in person. But also, what I think is important is when you have the defendant broadcasted through Zoom, well, we don't know, if the TV screen in the courthouse was as large as this, what the TV screen was like at the House of Corrections. For the witness who testified over Zoom, was she testifying through her cell phone? And why that's important is because the speaker through Zoom can determine, okay, am I going to use the speaker gallery? Is it going to be, are we going to focus just on the speaker? So you can manipulate it and say, okay, I don't want to see just a speaker. I want to see all 10 people, for example. Through this Zoom, for right now, Your Honors, if somebody wanted to, they can focus just on me, or they could focus on just everybody here. And you have little pinpoint examples of each and every person. So the reason, to get back to my initial argument, if I may, is the colloquy is very important. It's going to advise the defendant that he at least has an option to be in person, to sit next to his lawyer, to ask him questions, to actually see the witness if he wants to. He was not even given the option to ask the judge to require the person who testified through Zoom to be here in person. The trial attorney only got to cross-examine the witness through a Zoom trial. We don't know how much.
So if we adopt your position and say there's a colloquy, tell me, and you just said, so the colloquy should at least say that he has an option to sit next to his lawyer.
Yes.
Tell us what the colloquy, again, assuming there is a colloquy, what should the colloquy say?
Okay, yes, Your Honor. So at the pretrial stage, for example, if somebody wants to change their plea in the district court, the judge will say through Zoom, something along the lines. You are through Zoom, you have a right to be here in person. If you want to be here in person, we will have you in and we'll continue to another date. If otherwise, you can waive it, we can do this change of plea through Zoom. I think that has to be one option for the defendant through this colloquy. The second colloquy has to be, question is, you have a right to confront your witnesses. You should be able to come into court and say, I want to see this witness face to face, and I want them to tell me what their version of facts is to my face, not over a Zoom hearing. And you should be given that option. And probably the most important option is whether or not he wants to sit next to his lawyer.
But counsel, on that, aren't the social distancing rules still in effect in court? Can he really sit next to his lawyer?
I see, perhaps, but he could still sit next to him within 6 feet. For example, don't count me on this, but if I sat here and the defendant sat here, I would approximate that's about 6 feet.
Mhm.
Forgive me if I'm wrong, but he should at least be there. If you look at the
And
trial.
what about, is there not a factor in this, in that if defendants go to court, leave the premises to the facility to go to court, that they are then quarantined sometimes when they return?
Sometimes. If that's the case, if that's the case, then the defendant should be isolated at the jail prior to the trial. He should be given the option to sit next to his lawyer. If you look at that trial, Your Honor, the defendant is actually physically closer to the court officer in the jail who has his handcuffs ready to put him back into jail rather than his lawyer. During cross-examination, for example, if they pretend we're the trial lawyer, the defense lawyer. He's standing there, he's listening to the prosecutor ask questions. He's jotting down his notes. Okay, this is what I'm going to attack at cross-exam. He's paying attention to the judge, see what's going on with the judge. And he's also expected to also see if the defendant is saying, hey, over here, look at me, I have a question for you.
Mhm.
And then the judge is supposed to say, okay, time out. We're going to take a breakout room, wherever that's located in the courtroom, which we don't even know how that's related to the courtroom. Is it next door? Is it down the hall? We don't know because the record doesn't say that. And also in this case, the trial judge never even stated anything about the breakout room to the defendant. So we don't know if the defendant actually knew there was a quote unquote breakout room. And we also know that, Your Honors, because if you read the trial attorney's affidavit, he doesn't state that he advised the defendant of a breakout room, or if the trial attorney even knew of this breakout room. This case is just, for lack of better words, it just flew by the seat of their pants.
Well,
there
let me ask you this, if I could, please. I really don't understand why there wouldn't be a colloquy. Why not? Why not have the defendant have all the understanding and information that he or she can have as far as the colloquy? Colloquy makes sense, but to construct the colloquy, we need to understand what constitutional rights we need to warn and explain about.
I think
So just hold on.
I'm sorry,
It's a
sorry.
real, I don't know if the answer is simple, the question's simple. But don't we first have to decide during a pandemic, following on Vasquez-Diaz and a motion to suppress, during a pandemic, what are the constitutional rights at trial that we should look at differently than we did for a motion to suppress?
I think it's different for Vasquez-Diaz in a couple of different manners. In Vasquez-Diaz, Your Honor, as you just stated, it was a motion to suppress. In this case, we have a trial. It's the fact finder's last opportunity to determine credibility of a witness. It's the last opportunity for the judge or the jury, maybe in future instances, to say, they changed their testimony last time, or to be taken away the judge's role or the jury's role to see the demeanor of a witness. I think we've all seen things like somebody says, he's lying. And you say, how do you know he's lying? Just look at him. Just look at him. He's lying. We all know he's lying. You're taking that away from the defendant to have somebody on a 1-inch screen through Zoom. So that's why that's important. He also has, I think, at least have, through Rule 18, he does have a right to be present through critical stages of the trial. I think we all agree that the trial is a critical stage. The question is, does he have a right to be face-to-face? I would say yes. At least give him the option of that. In this trial, he wasn't even given that option. It's like, okay, you're going to stand there at the House of Corrections in your, I am assuming your greens, and the one witness who's going to identify you is going to identify you as the only person sitting at Zoom hearing. The other issue is, what rights does he have to sit next to his lawyer? I've done trials as well, Your Honors, for what it's worth. They always ask some type of questions. It might be a bad question. It might be irrelevant. The trial attorney might say, no, I'm not going to ask it because that's just going to open up a can of worms. But for the defendant to be on a Zoom, probably 20 miles away, like I said earlier, is actually closer to the corrections officer, I think that's inherently unfair, a violation of due process. I understand the pandemic has made everybody work harder. It's made everybody's life more difficult, especially the courthouses. Yes, we probably still have to social distance, but we can't have trials where the defendant and his lawyer aren't even sitting next to each other or aren't even given the opportunity to sit next to each other. This is what our Constitution and Massachusetts
Well, but
Declaration.
wasn't your client given that opportunity? I mean, there had to be agreement to proceed under a bench trial, didn't there?
Well, they did agree to a bench trial, but there are different rights.
And didn't they agree to do it on Zoom?
That I don't know.
You don't know. Well, how did that happen then?
I don't know.
I see.
To be honest, I don't know.
I thought the attorney's affidavit said he informed him of his right to be present for the bench trial.
I would like to speak a little bit about that. For the trial attorney's affidavit, I would like you to.
Am I remembering that right?
No,
Before you spin it, did it say that?
It said, to the best of my knowledge, I informed him of his right to be here. But it's also important because if you look at the paragraph before that, it says, I can swear that I told my client about the right to a jury trial. But even if he told him of his right to be there, he did not advise him of his right to confront face to face. He did not advise him of his right to sit next to him at trial. He did not advise him of his, the Zoom breakout rooms.
And
Well, he said, yeah, you
didn't Judge Oconto say that his practice was to tell people you could either be here or do it over Zoom?
Even if that is his past practice, he didn't do it that day.
Well, how do we
Just answer my question. Did Judge Oconto say my practice was to do it that way?
Yes,
Okay.
yes. Let's see. Any questions before I jump right to my last?
Well, I don't know if you finished the colloquy that Justice Kafka asked you to create. There was you have the right to be here in person, the right to confront witnesses and see them face to face and sit next to your lawyer. Was there anything else?
I think those are the most important because the defendant.
And then, okay, so my other question is, this is an odd, maybe it's not odd, but there were certain people who were physically present in the courtroom.
Correct.
Who was that? Defense counsel?
So defense counsel, the prosecutor, the judge, and 2 of the 3 witnesses.
Okay, so the only people who were participating by Zoom were the defendant and the main witness.
That is correct, Your Honor. It is a very strange case, for lack of better words, as you pointed out.
And we have nothing in the record to explain why that was the case, right? Given that certain people were going to be all together regardless of COVID, and the defendant was not.
I do not have a very good answer for that. I looked high and low on the docket sheet through the record, everything from arraignment to the trial, and at no point was any guidance given. That's why I think this court has a duty to say, if we're going to have bench trials or jury trials through Zoom, there must be some type of guidance provided from this court to say, okay, defendant, you have these rights. And unless there are any other questions from the panel, I would rest on my brief.
Okay, thank you very much.
Thank you very much, Your Honors.
Attorney King.
Yes, good morning. May it please the court, Michelle King, Assistant District Attorney for the Commonwealth. The issue before this court is whether the Zoom bench trial during the height of the COVID-19 pandemic, in which the defendant appeared via video conferencing, violates his constitutional right to confront witnesses, to be present, to have a public trial, and to the effective assistance of counsel. And as defense counsel has pointed out, whether a colloquy advising the defendant of those rights is constitutionally required. The issue, whether the Zoom technology is perfect or implicates some of the concerns.
Can you set the facts for us? Because I'm trying to discern what we know from this record about the Zoom trial and what the defendant was informed of that and what we look to on that.
Yes, Your Honor. So this was the culmination of a period of time in which the defendant had a number of pre-trial hearings and a dangerousness hearing over Zoom. In March of 2000, he had a dangerousness hearing over Zoom, and then he had, I believe, 4 or 5 pre-trial hearings, all which occurred over Zoom technology. There was a hearing on July 31st prior to his trial, which occurred on August 24th, I believe, whereby the defendant thought that he was going to be released pre-trial, and that belief was based on that the victim in the underlying case was going to come into court and say that she wanted him released despite the dangerousness finding, and that she wanted him to live there. And that was all in the appendix that I submitted, Your Honor. And the victim did appear that day, and as did the defendant via Zoom. And long story short, the motion judge did not release the defendant on that day because he had some concerns. A month later, a little bit under a month later, the defendant had this Zoom trial. And if you look at the beginning of the transcript, it seems to start, the trial seems to start kind of abruptly, as defense counsel noted. If you look at the first page, the case isn't even called yet. So you don't have the clerk saying, you know, Commonwealth v. Curran or whatever. It just jumps right into the jury waiver colloquy that Judge LeConte.
That's what I'm concerned about. So again, you know, our order says you've got to make a it has to be voluntary to go to a Zoom trial, right?
Correct.
And I mean, you sort of need to know the difference between a Zoom trial and a trial, right? For that to be an informed decision or an agreed upon decision, don't you need to know the difference? And how do we get comfortable with that, given how little we know? I mean, there's some discussion about this breakout room, but again, I don't see it in the record. I see the one comment in the judges on the tender point, but I'm just trying to get a sense of how we get a sense that the defendant understood the difference between a Zoom trial and a bench trial in court.
Yes, Your Honor. So what we do have in this record, although not explicitly stated, is that, well, certainly stated on the record at the hearing prior to the trial, is that this defendant is no first-time defendant. He has had a number of cases before, which occurred prior to the pandemic, in which he had appeared in person. He had a number of pre-trial conferences, hearings rather, and conferences in this case prior to his trial. So he certainly knew what transpired during the Zoom process. And just to a quick point, and I'll get back to more of the evidence in this case, but it's also important to note that the defendant didn't object to any of the constitutional, to the quote, lack of constitutional rights to which he now claims. And so that places this solidly under the standard of review of substantial risk rather.
Can I ask about that? And again, my colleagues who are more familiar with, who gave these colloquies every day may have more insight in this. But so if you forget to give a colloquy, we tend to reverse, right? So if there is a colloquy required.
But if the
Go
colloquy
ahead.
is required, yeah, I'm sorry, Your Honor, with the Zoom, I didn't mean to speak over you.
No,
With-
I apologize because I can't tell when, I'm sure you're having trouble telling when I'm talking. Go ahead. Mhm.
In cases where a colloquy is required, that may be the case. But if you look at the Commonwealth case, which I'm not sure I'm pronouncing that correctly, but even in the case of a jury waiver, this court has said that constitutionally speaking, a colloquy is not required. And while it may be the best practice for judicial administration and going forward, the court said that that colloquy should be given, it's important to note that the court said it's not constitutionally mandated. And I would suggest to you that.
And I agree with that, but we also always reverse if you don't give it, right? So is this a circular in a sense, whether we've got to determine whether, and I agree, it's not constitutionally required. It's a superintendent's requirement, but don't we have the same issue presented here? I mean, I guess the issues to me are, one, is there a superintendent's or even out of our own order requirement of some kind of colloquy? Two, is it prospective or retroactive? And three, can it be harmless? And four, what is the colloquy? I mean, are those the right issues?
I think those probably are the right issues. I've already forgotten in which order, but to talk about them. But essentially speaking, while this may be again, it's not a constitutional requirement, and while it may be an issue of best practice or superintendents, there was no order in place at that time that required such a colloquy. So you would, during these very difficult times of the COVID-19 pandemic, when judges were really trying very hard to do this on the fly and figure out what was required, I would suggest to you that the Fitchburg District Court did an amazing job of.
But how do how do I know they did it? I mean, I have a tremendous amount of respect for this judge, but so how do I know he did a good job from this record? Because at a minimum, you do need to understand the difference between a Zoom trial and a bench trial in court. Also, I guess you need to know the difference between a bench trial in court during COVID in Zoom, because it's different from what a bench trial in court used to be. But I guess, can we determine that people made an informed decision here, or do we not even need to do that? And you decided to go Zoom and you took what you got.
Well, I think you can infer that an informed decision was made here, despite the fact that it is clear that the defendant did not receive a colloquy. And the reason for that is because you have the affidavit of defendant's trial counsel who said, to the best of my memory, I can say that I advised Mr. Curran that he could appear personally in court and be heard during his trial and did not have to try his case over Zoom. You can infer from the defendant having that information that he declined to do so. Otherwise, he would have been present in court on the day of his trial.
Counsel, can I ask you one quick question?
Yes, yes.
You mentioned that at the time of trial, Mr. Curran was held on an order of dangerousness.
Yes, Your Honor.
And was that 58A hearing, was that conducted over Zoom, or did they stipulate it was evidence taken? When was it taken substantially the same way the trial proceeded?
It was conducted over Zoom, Your Honor. It occurred in late March after all of the courthouses had been closed. It was conducted over Zoom, and it was an evidentiary hearing, essentially.
Did the complainant testify in the same way? Do you know?
The complainant had been, I believe, if I'm not mistaken, the complainant had been sort of up and down all along. At the trial, she testified essentially that nothing happened, but the reason why the Commonwealth went forward was because there was the testimony of the police officer who had observed the victim right after it happened, and also of the percipient witness who viewed the violent attack. And I believe that was presented at the dangerousness hearing as well. That's why the defendant was held.
And just last question on that. Do you know if the defendant was present or was the defendant present over Zoom?
The defendant was
for-
Zoom throughout the course of the proceedings on this case. He always appeared over Zoom.
Thank you, counsel.
You're welcome. Just
Ms. King,
sorry,
Ms.
I
King,
lost.
I'm sorry, Ms. King. At some point as we go through this, we need to think about, for instance, I'll just take the confrontation clause face-to-face provision first. We need to think about, during a pandemic, the differences between a motion to suppress and a bench trial where there's been a jury waiver colloquy, and then measure during a pandemic the right to confront witnesses face-to-face. Do you have any help for us in that?
Well, I would say a few things, Your Honor, and I understand the differences between certainly a motion to suppress hearing and a trial, and they are different. But I would suggest to you that once a constitutional right attaches, so in Vasquez-Diaz, this court said that a motion to suppress is a critical stage in a defendant's proceedings. And so once the constitutional rights attach or are implicated, I would suggest to you that the analysis is essentially the same, and then it's an application of the facts in this case. And so in Vasquez-Diaz, this court talked quite a bit about the right to confront under Article 12 and also under the Sixth Amendment, in stating that the COVID-19 pandemic did create a necessity for having motions to suppress in that case held via Zoom, and that the Zoom proceedings were reliable. Now, of course, Vasquez-Diaz is also different because that defendant wanted to not have his case heard via Zoom. He wanted to wait, and that was a big difference. In this case, the defendant was very eager to have his case heard, and that's quite apparent from the hearing prior to the trial, and from the defense counsel's affidavit that the defendant wanted to go forward. And so, given weighing out the defendant's right that he wanted to go forward, along with the significant public health concerns to the defendant and having him transported, and there was information in this record that the defendant, one of the reasons why he was so eager and urgent to be released from his sentence, along with the fact that obviously nobody ever wants to be held, is that he was sick and he was very concerned about contracting COVID along with his other medical situations. And so when you look at that with the public health concerns of transporting a prisoner, that whole process to the courthouse, the public health concerns for court staff with somebody from an institution coming in, I would say that Vasquez-Diaz it applies directly, even though this is a trial and Vasquez-Diaz was a motion to suppress.
Okay, are there any other questions? Do you have anything else, ADA King?
I don't, Your Honor. Thank you very much. I'll rely on my
Thank you.
brief.
Thank you.